కదా
Okay.
మీరు in that link only you join at 1:30.
Okay. Okay, sir.
So
Okay, sir. Thank you, sir.
yeah. So actually in this mercantile law, there are 4 types of broad categories of acts that you have to study. The first act is the Indian Contract Act. Okay, the Indian Contract Act is again divided into 2 parts. The first one is called the General Law of Contracts. Okay, the General Law of Contracts is the first part that we will cover in block 1. Then in the second block, you have got the special contracts. Contracts which are, say, the contracts of indemnity and guarantee, bailment and pledge. They are special kinds of contracts, and the treatment with this kind of contract is different. That's the reason why they are called special contracts. And then in the third block, you're going to talk about the Sale of Goods Act. Okay, in the Sale of Goods Act, we will see what is the contract of sale of goods and how the transfer of ownership of goods will take place from the seller to the buyer, and how does the performance of the contract of sale take place. And in case, see, when a seller is selling the goods, he will sell the goods for an amount known as consideration. Okay, now if this consideration is paid by the buyer, the contract will come to an end. But in case the consideration is not paid, then there is a breach of contract. If there's a breach of contract, what are the different things that have to be taken care of is what we will see in the performance of the contract of sale. Then in the 4th unit or 4th block, we will talk about industrial law. Okay, industrial law, more specifically the Factories Act, we will see what are the duties of the occupier, what are the safety measures, what are the welfare measures that have to be taken by the factory owners. Okay, what are the different types of remedies available to the workers under the Factories Act is what we will see in the Factories Act. Then there is another act called as the Industrial Dispute Act of 1947. We will talk about what is an industrial dispute, how the dispute grievance mechanism is laid down in the act, how the grievance has to be readdressed, and what are the various measures the company has to take, the factory has to take in this regard is what we will see in the Industrial Disputes Act of 1947. Then we have got the Employees Compensation Act. Okay, it was previously called as the Workmen's Compensation Act. In case there is an injury in the factory and the worker becomes permanently disabled or temporarily disabled, what are the different compensations that have to be paid, in what situations the compensation has to be paid, and in what situations the compensation payment can be avoided. Okay, is what you will see in the Employees Compensation Act. Then in the last block, you have got the Consumer Protection Act. Okay, the Consumer Protection Act, the Intellectual Property Rights Act, and the Information Technology Act. These are the 3 acts that we will see in block 5. Okay, so this is an entire overview of this subject called as mercantile law. Okay, so in today's class, we will talk about block 1. Okay, as I was telling you, block 1 talks about the general law of contracts. Okay, now what is the meaning of law in the first place? What do you understand by law? Law has got different meaning for different people. Okay, say for example, in case you are a student who is studying law, for you law is a subject of discipline. For the courts, law is something that they have to enforce. The courts have to enforce the law. For an ordinary common citizen, law is something that has to be followed. Okay, for a lawyer, law is something that he practices. Okay, so there are different connotations or different meanings of law in the different contexts in which you are using. In our context, mercantile law is that law that deals with mercantile transactions. What are mercantile transactions? transactions that are entered into by merchants in the process of sale and purchase of goods. Okay. When there is a sale and purchase of goods, you have the Sale of Goods Act. Okay. And there are different contracts which the parties enter into. What are the various ways in which a contract is entered into? What is a contract in the first place? Who are the parties to the contract? How the contract is entered into to be called as a valid contract? What are void contracts? What are voidable contracts? What are quasi contracts? All this we will see in this first block. So first we will talk about unit 1, the nature of contract. Okay. Now, a contract is an agreement enforceable by law. A contract is an agreement enforceable by law. Now here, what is in this? I've just made a statement. I said a contract is an agreement that is enforceable by law. Now here, there are, if you see, just 1 minute. So here, if you see, there are two essential things in this statement that I've made. One is it should be an agreement. Second, it should be enforceable by law. Okay. So here you see an agreement that is enforceable by law is known as contract. What is an agreement? Agreement is when two or more people agree to do something, agree not to do something. Okay. That agreement is known as contract. Okay. When two or more people agree to do something or agree not to do something, that is known as an agreement. Okay. So agreement is every promise and every set of promises forming consideration for each other. Every promise, every set of promises forming consideration for each other. Promise, what is the meaning of promise? To do something or not to do something is a promise. Why is this promise made? Promise is made in return for something. That return for something is known as consideration. The return for something is known as consideration. Okay. So where there are two parties, say party A and party B. Okay. Now party A promises party B that he is going to deliver goods. Okay. Now this is a promise. This is a promise. So the first part we have said is an agreement. We said agreement is a promise to do or not to do something. Then what is the meaning of enforceable by law? Okay. Enforceable by law. Now somebody is asking me what is the page number? Page number 4 of your study material. Page number 4 of your study material is what I'm discussing. Okay. So in the second thing, we said agreement has to be enforceable by law. What is the meaning of enforceable by law? That is, the courts should recognize this agreement as it can be accepted in a court of law in case the agreement is broken. Suppose, for example, A tells B that he is going to invite him for dinner on Sunday. Okay. A is telling B that he is going to invite him for dinner on Sunday. This is a promise. Okay. And A has to invite B for dinner on Sunday. But do you think that if B doesn't invite A to his house for dinner, will A go to the court of law? He cannot. Why he cannot go to the court of law? Because these agreements are social agreements. Okay. They are not mercantile agreements. They are not business agreements. Suppose if A had told B that he would deliver goods on Sunday and he does not deliver, then B can file a case against A. But if he is only telling him that he'll call him for dinner on Sunday, and in case he doesn't call him, then B cannot go to the court of law because these are social agreements. Okay. So here we have defined what is a contract. We said a contract is an agreement that is enforceable by law. Okay. So agreement enforceable by law is a contract. Now, for any contract to be known as a contract, there have to be certain essential elements. Now, this is very, very important from examination point of view. The question would be, what are the essential elements of a contract? What are the elements of a contract? Or when is a contract valid? Okay, these three type of questions may come. For all this, the answer is the same. The answer is given in your study material 1.3, page number 5, the elements of contract. Okay, so listen carefully. This is very important from examination point of view. The first one is offer and acceptance. There should be an offer by one person and its acceptance by another person. This is the first essential element of a valid contract. Okay, so this we will see later on. What is offer? What are the legal rules of a valid offer? What is acceptance? What are the legal rules of a valid acceptance? We will see later on. But for now, understand that one of the essential elements of a contract is the first, there should be an offer by one person and its acceptance by another person. That's the first one. Second one is legal relationship. Okay, legal relationship. Now, the agreement that has been entered into, okay, should create some kind of a legal relationship among the parties. Okay, just now I gave you an example of A inviting B for dinner. We said it is not a contract because it is not a mercantile agreement. Okay, we said it is not a contract because it is not a mercantile agreement. So the agreement should be such that it has to be capable of creating a legal relationship between the parties. Now, example, say A promised his wife B to give a sari if she sings a song to him. Okay. Now, is this a valid contract? No, it cannot be a valid contract because the intention of the parties is not to create any legal relationship among themselves. Okay. Then here, one very important case law is given. In your mercantile law subject, you are given case laws. You will have to mention that case law when you are giving one specific point. For example, you said the second essential element was legal relationship. So for legal relationship, there is a case law. This case is called Balfour versus Balfour. Balfour versus Balfour. Now, in this case, a husband promised his wife that he would pay an allowance of 30 pounds per month to her after he goes to Ceylon. Okay, after the husband goes to Ceylon. Ceylon, by the way, is in Sri Lanka. So the husband, while leaving his wife here in India, he told her that after he goes to Ceylon, he will pay 30 pounds per month to her as maintenance. Okay. Out of goodwill, he said he is going to send $30, 30 pounds per month to the wife back in India. Subsequently, after a few months, in the first few months he has paid, but after a few months, he stopped paying this allowance of 30 pounds. The wife went to the court of law, asking the court to direct her husband to pay her this 30 pounds that he had promised. Okay, there was a promise. Promise was between two persons, A and B, that is the husband and wife. The promise was for a consideration, but the court of law said that this agreement is outside the realm of contract. Okay, outside the realm of contract, because this is a social agreement. Okay, agreements which are social in nature are not valid contracts. Okay, that is the second important point. The third one is lawful consideration. Okay, now lawful consideration meaning, what is consideration? Consideration, as I already told you, is a return. Something in return is known as consideration. Suppose I purchase a cell phone in the market. The price that I pay is the consideration. Now, the consideration in any contract has to be a lawful consideration. Suppose, for example, A tells B that if B beats up C, thrashes C, then A will pay 1,000 rupees to B. Now B goes and thrashes C. He beats C. He comes back to A and is asking to give that 1,000 rupees. A refuses to pay. He says he will not pay. Can B go to the court? He cannot. Why? Because the consideration is unlawful. You cannot beat up a person just like that. Okay. So here the consideration is unlawful. Therefore, it cannot be a valid contract. Okay. That was the third point, lawful consideration. Then capacity of the parties. Whenever two parties enter into a contract, they should be capable of entering into a contract. What is the meaning of capable of entering? Capacity to contract. Now, Section 11 of the Indian Contract Act says that there are three parties who cannot enter into contract. One, a minor. Minor is a person who has not completed 18 years of age. So he cannot enter into a contract. Second, persons of unsound mind. Persons of unsound mind. Where a person is not of a sound mind, others might take advantage of him. So therefore, any contract entered into by a person of unsound mind cannot be a valid contract. Okay. Third one, persons prohibited by law to enter into a contract. Okay, persons prohibited by law to enter into a contract cannot enter into a contract because there is a law that says, there is a court ruling that says that they are not eligible to enter into contracts. For example, a person who is declared to be insolvent, okay, he cannot enter into contract. Like that, three parties cannot enter into a contract. One, minor. Second, person of unsound mind. And third, a person prohibited by law. Okay. So capacity of parties also is very important. Only when the parties are capable of entering into a contract, they can enter into a valid contract. Then third, free consent. The consent means their acceptance. Okay. Now, where a person enters into contract not by his own will, but he was forced to enter into a contract, either by threat or by inducement or by any undue influence or by misrepresentation or by fraud or by coercion. When he is forced to enter into a contract and his heart is not in the contract, then it cannot be a valid contract. So persons have to enter into a contract out of their own free will. Okay. Then sixth one is lawful object. Object meaning the subject matter of contract. The purpose for which the contract is entered into has to be a lawful object. Suppose, for example, two people agree to enter into a contract to smuggle goods into the country. Smuggling is unlawful. So what is their object? The object is the attainment of an unlawful thing. Therefore, it is not a valid contract. Okay. So here the consideration has to be lawful. The object also has to be lawful for entering into a valid contract. Then certainty. The outcome of the contract has to be certain that it will happen. It cannot be a doubtful uncertainty. Suppose X and Y enter into a contract saying that X will pay Y rupees 10,000 if it rains on Monday. Raining on Monday is not a certain event. It is an uncertain event. So because the event is uncertain, the contract is not valid. For contract to be valid, the event has to be a certain event. It has to be an absolute outcome. Only then it can be a valid contract. Then possibility of performance. The contract should be such that the party should be able to perform it. Suppose, for example, I enter into a contract with a person saying that I am going to raise up one person from the dead. A person has died and I have taken money from another person saying that I will raise him up from the dead. Is it possible? It is not possible. So where the possibility of performing the contract is absent or nil, the contract cannot be a valid contract. Okay. Then writing and registration. See, the Indian Contract Act says that agreement can be either oral or written. You can enter into an agreement by word of mouth. That is called as oral agreement. Or you can write this down in a piece of paper. Okay, in a bond paper, you can write it down. It is a written agreement. The Indian Contract Act does not prohibit a person from entering into an oral contract. But however, there are certain contracts which have to be in writing only. So where contracts specifically have to be in writing, such contracts can become valid only when they are put down in writing. If they are oral in nature, they cannot be called as valid contracts. Then the last one, not expressly declared to be void. Not expressly declared to be void, meaning that the contract should be such that the courts have not declared these contracts to be invalid contracts. So when the court has not declared a contract to be invalid, such a contract can be validated by the parties when they enter into. But when the court has already declared certain contracts to be void, for example, contract with a person who is a citizen of an enemy country. Okay. So where there's a person who is a citizen of an enemy country, you should not enter into contracts with persons of enemy countries. That is the law. So all contracts entered into by persons of enemy countries are void. So that is why you cannot call them as valid contracts. So for a contract to be valid, these are the 10 essential elements that have to be present. Only then you can call them as valid contracts. Otherwise, they become invalid. Okay. So these are the elements of a valid contract. Now, at this point in time, I'd like to leave the class because at 11:30, you have another class. Probably at 12, you have another class. Okay. Is it correct? Are you there with me?
Sir. Yes, sir.
When do you have your next class?
12. 12.
12 o'clock. Huh?
12 to 1.
12 okay, to 1. Very good. Okay. So, did you understand what I was trying to tell you here, children?
Sir, yes, one question, sir. Sir, one question, sir.
Tell me.
Sir, you tell me in the business statistics, right, sir?
No. Yeah. See, listen. See, you will have your business statistics class at 1:30.
Okay.
Because there was some adjustment. Madam cannot come at 10:30. I came.
Okay.
I was supposed to come at 1:30. Okay. But now you will have business statistics at 1:30. Okay. Are we clear?
Oh, yeah.
Any doubts you have got up till here?
No, sir.
No, sir.
No, sir.
So this is about your unit 1. Okay.
Sir, which class did you take, sir, actually?
I have taken
mercantile
law. Mercantile law.
Commerce 12. Commerce 12.
Commerce 12 I have taken.
Okay, right.
So you have listened to the entire class without knowing which subject you are listening to. Yes, gentlemen, what is your name?
My name is Sallu Rahman, sir.
Yeah, Rahman. So you have listened to the entire class without knowing which subject it was. Anyway, it was mercantile law, Commerce 12.
Okay.
You will have next after this, you will have your Commerce 11. And after that, you will have Commerce 10, which is business statistics.
Okay.
So quickly, we have got, I think, 4 more minutes. I will just talk about the second unit, which is essentials of a contract. See, I have told you that there are 10 essential elements of a valid contract. Now, each of these 10 essential elements will be dealt with separately. The first one, what we said, was offer and acceptance. So, in the second unit, you will understand what is an offer. What are the legal rules regarding a valid offer? Okay. What is an offer? Now, here you see, I'm defining offer when one person signifies his willingness, signifies his willingness to do something or abstain from doing something, with a view to obtaining the assent of the other. Such act or abstinence is said to be a proposal. And a proposal has to be accepted by the other person. So here, offer, I will just give you an example. I want to sell this pen to you. I want to sell this pen to you for ₹50. Here, I am there. I have made an offer to you. An offer saying that I want to sell. Sell what? The pen. This is the subject matter. For what? For ₹50. 50 is the consideration. To whom? To you. To Rahman. So here I am telling to Rahman that I will sell my pen to you, Rahman, for ₹50. So here what I have done, I have made an offer to do something. So offer may be positive, or I have made an agreement with Rahman saying that I will not open my shop just beside your shop. I will not open my shop just beside your shop. If you give me 1 lakh rupees. Here what I have made? I have made an offer to Rahman, telling him that I will not open another shop just beside yours if you pay me 1 lakh. So here I have offered not to do something, not to set up the shop. So this is negative. Positive is to do, negative is not to do. So offer may be to do something or not to do something. That is an offer. Okay. Now, for an offer to be valid, there are certain legal rules regarding a valid offer. Okay, there are certain legal rules regarding a valid offer. The first one, an offer may be express or implied. See, you will listen to this term express or implied many times over and over again. What is express? Express mean where I have conveyed my offer to you by words spoken or words written. That is an express offer. I have told my intention of offering the pen to Rahman either by words spoken or by words written. This is an express offer. What is an implied offer? An implied offer is that offer that is understood by the behavior of the parties, but no word is spoken, no word is written anywhere. For example, TSRTC is running a bus from, say, Jubilee Hills to Madhapur, and a passenger gets in. Here, the fact that a bus is being run from Jubilee Hills to Madhapur is an implied offer asking people or passengers to get in if they want to be dropped at Madhapur for a fare that is fixed by the TSRTC. Now here, the conductor will not, ask everybody to get in. Just running the bus from route A to route B is an offer made by the conductor, is an offer made by the transport company, offering to transport people at the fare fixed by it. This also is called as an offer, but because no words are spoken, no words are written, it is known as implied offer. That is the first one. Offer may be express or implied. Okay. Second is, offer must contemplate to give rise to legal consequences and should be capable of creating legal relation. Okay. This example I have told you before. As A telling B that he will invite him for dinner. The intention is not to create any legal obligation. So it is not a valid offer. Okay. But however, if you go and have a meal in a hotel, okay, that is an implied offer made by the hotel that this meal is available at this price. If you want, and you go to a hotel, you sit on the table and then you order something. Here what you have done is you have placed an order on the implied offer made by the hotel management. Okay, so there is a legal obligation, you have to pay. But if you go to a friend's house for dinner and the friend has given you dinner, you cannot ask, the friend cannot ask you to pay something because it is not a creating legal obligation. Then the third one, the terms of offer must be definite. They must not be ambiguous or vague. What is ambiguous? For example, say I told you here, I will sell this pen for 50. This is definite. If I say I will sell this pen for a suitable price, I said a suitable price. What is suitable? 50 rupees is suitable for me, but for you 500 is suitable. Okay. Suppose, for example, I will purchase a cell phone and then I say I will pay you a suitable amount. that is not a valid offer because the term suitable will differ from person to person. Therefore, it is not certain. That cannot be a valid offer. Then an invitation to offer is not an offer. Suppose, for example, you know what is the meaning of a prospectus. What is a prospectus? Prospectus is an application inviting the public to subscribe to the shares. So here it is an invitation to offer, but not an offer. So there has to be a distinction between offer and invitation to offer. Then the offer may be specific or general. Now this is very important. Here, for example, I told you, I will sell the pen to Rahman for 50. This is specific offer to Rahman. Suppose I said, I will sell this pen to the class of 19 students who are participating here for 50. This is a general offer. I have not signified that I will pay, I will give to Rahman, or I will give to Masi Reddy, or I will give to Samira. Okay, Samira, I did not tell the name like that. So where a name of the person is not specified, it is a general offer. While a name of a person is specified, it is a specific offer. There is a very famous case law here, Carlyle versus Carbolic Smoke Ball Company. Carlyle versus Carbolic Smoke Ball Company. Now here, there was a smoke ball company which gave an advertisement saying that any person who uses their smoke balls in the prescribed manner will not get influenza, will not get flu, is an advertisement given by the company. This is anybody, a general offer. Anybody who uses our smoke balls will not get influenza. There was one lady called Mrs. Carlyle. Mrs. Carlyle purchased the smoke balls, used them as per the instructions given, but still she got influenza. She filed a case against the company saying that the company said any person who uses our smoke balls will not get influenza. But I have used the smoke balls as per the instructions, but I contracted influenza. Now the company has to pay me the compensation. The company had given an advertisement saying that we will pay £100 to any person who gets influenza, even after using our smoke balls. This was the claim of the company. Now this lady said, I have used, but I got influenza. Now I have to be paid that £100 which the company is promised. The company said, we never entered into a contract with Carlyle. Why should we pay? Is what the company said. The court of law said, offer may be specific or general. When you said anyone who contracts, you made a general offer. Any person who has used this smoke ball